I'm speaking today about hints and tips for effective advocacy. I like to break my advocacy down into three areas: preparation, presentation, and points. Now, I think preparation is key. It's really obvious to judges, opponents, clients, and witnesses alike whether we've done enough preparation and we're on top of our case when we get into the courtroom. I start my preparation by reading the bundle, and I read it cover to cover. I then sit and reflect on what the themes are for my client's case. So I'm a childcare lawyer, and for example, if a local authority are concerned about the care that a parent's given to a child, and those concerns may centre around domestic abuse, whether the children are being taken to school, etc. I will take each of those themes and run that through my advocacy preparation in terms of what questions to ask witnesses. And that's questions of witnesses that may enhance my client's case, but it's also questions of witnesses to damage limit anything adverse to my client's case. So once I've identified those themes, I will then go back through the relevant documents in the bundle and do a list of the key points that I want to ask questions of the witnesses about. Now, I think it's really important not to write a script, not to write those questions out. It's almost impossible to be on your feet addressing the judge or asking questions of a witness and being able to follow the question you've set out. Much more preferable is bullet points, so that you can cast your eye down and then proceed with those points that you want to elicit from that witness. The bullet point system also gives you more flexibility. We can't predict all the answers that we're going to get. Some answers may need developing, and some answers may need stopping in their tracks and moving on to a different point. And it's much easier to do that effectively if you're not reading from a script, but instead using bullet points. And the next point I want to think about is that of presentation. Now, some of these are obvious. You need to be smart. You need to adhere to the rules of the court. We are, of course, officers of the court. We're there to assist the judge and we're there to assist the court. It's important that we don't mislead. In terms of addressing the judge, the Solicitors Regulation Authority have prepared a really helpful handout and guidance about this. And within that contains all the different terms of address. It's crucial to have the correct one for your case. Presentation also means understanding what the rules of advocacy are, understanding how to examine a witness in chief, and understanding how to cross-examine a witness. It's also really important to maintain eye contact with the witness. You're much more likely to get the answers in the case that you want, and much more likely to be able to follow that witness and ask supplemental questions and develop points if you've got a rapport with the witness that you're asking the questions of. In terms of the third P, that is about the points we make. Now, obviously, it's important to make the points that are going to help our case, but advocacy, in my view, is an interactive process. It's important, if a point is not going your way, to reflect on your advocacy. It may be you have to not follow the bullet points you've made of the questions, because actually it's in your client's best interest to stop a line of questioning that's not helping. In just the same way that adverse points to your client's case may need to be put to a witness, it may be that they change their view, or it may be you can damage limit the points that don't help you by asking questions of those witnesses. It's also important to listen to what's going on in the courtroom and to watch others. Is the judge writing down what you're saying? Is he writing down what the witness is saying? Is he interested in your line of questions? Or is the judge disinterested? Is he or she not very interested in the point being made? Should you stop? Is that a good hint? Or actually, is it a point that you need to make in order to act in your client's best interests? I think the next point that's important within this heading is that of vulnerable witnesses. The Advocate's Gateway and the toolkits that they provide are invaluable to practitioners. There's a wealth of information on their website, and the training that accompanies those toolkits is also invaluable. It's important where you've got a vulnerable witness that you adhere to the ground rules that will no doubt have been agreed in advance of the hearing. And whilst it's for the judge to ensure that a witness is being given the breaks or the assistance in the way that was envisaged, again, as an officer of the court, it's important that you assist the judge with that. The judge may be writing down something that a witness has said, whereas you're looking at the witness and you can see that they're upset or they need a break or they need the assistance of their intermediary, if there is one, and that it's for you to bring that to the court's attention and to see whether or not the judge wants to have that break. And everything I've said about both cross-examination and the examination in chief also stands for submissions. When you prepare your submissions for delivery in court, it's important to stick to your best points to deal with anything that does damage your case. Again, I would advise not to script that. You're going to lose some of the judge's attention if you are just reading from a script. Really important to ask the judge at the end of your submissions if there's anything else you can assist with. It's much better to deal with those in advance of the judgment in terms of being able to elaborate on points beneficial to your client, but also to try and damage limit those points that haven't assisted your client's case.